Good afternoon and welcome to In Focus with Silvana Pavlovska. We are going to continue with the research paper we started a few days ago. This research paper has only recently been published by AGM Knjiga, Belgrade, 2023, and it is a paper written by the distinguished professor and expert on international law, Professor Dr. Igor Janev. The Prespa agreement as cultural genocide of the Macedonian national identity towards the termination of an illegal treaty. Yesterday, we brought you the second chapter of this research paper, and we did so partly. So today is the second part of this chapter 2 contained in the book. So 2.3, legal implications and consequences of the imposed admission conditions for United Nations membership, the Macedonian case and derogation of personality. We shall now turn to a more substantive analysis of the additional illegal conditions imposed on Macedonia by the UN organs for its admission to UN membership. We remind at this point again that they include unconditional acceptance by the applicant of needed unnegotiable requirement, 1, of being provisionally referred to for all purposes within the UN as, in quotation, the former Yugoslav Republic of Macedonia, end of quote, pending settlement of the difference that has arisen over the name of the state. That is, bypassing official applicant's ID in the UN and replacing it with baseless, arbitrary, limited designation. And unconditional requirement, number 2, of negotiating with direct adversary plaintiff, Greece, over its for unrecognized name implied in the second part of the above cited text common to both the General Assembly Resolution 47/225 from 1993 and the Security Council Resolution 817 from 1993, and from the provision in the Security Council Resolution 817 by which the Security Council urges the parties to continue to cooperate with the co-chairman of the Steering Committee of the International Conference on the former Yugoslavia in order to arrive at a speedy settlement of the difference. The vague reason for imposing these political conditions was given in the preamble of the Security Council Resolution 817, 1993, in which the Security Council, after affirming that the applicant state fulfills the conditions of Article 4, observes that a difference has arisen over the name of the state, which needs to be resolved in the interest of the maintenance of peaceful and good neighborly relations in the region. The Security Council didn't mention or indicated any security risks other than the difference over the state's name that was a subject of non-recognition by one member state that generally do not politically recognize national identity of the candidate for UN membership. The observation of the Security Council based on the name dispute solely, which has generated the imposition of the mentioned additional conditions for the Macedonian admission to the UN membership, was apparently based on the groundless Greek allegation that the name of the applicant implies territorial claims against Greece. The assessment and recommendation of the Security Council didn't take into consideration that there was not one Macedonian region, but 3 administrative regions created in 1987, and all of them with different names than the applicant name. That is, name of the international subject. State's name that is not in the same category as provinces' designations, names in other states. Without examining the legal basis of the Greek allegation, see later for detail on this aspect, says Professor Dr. Igor Janev, the Security Council, in accordance with its responsibility for the maintenance of world peace and security provided for in Article 24 of the Charter, has used the above political consideration as a sufficient basis for imposing the additional conditions on Macedonia for its admission to UN membership. We have already seen that this is not in accordance with the GA resolution 197, paragraph 3A, and the court's interpretation of Article 4, paragraph 1. However, there are other and perhaps even more important legal implications of the imposed additional political conditions, particularly with respect to Jus Cogens norm of self-determination, Article 1 and 55 of the UN Charter. First of all, provisional designation may not serve as a legal name in the organization composed of sovereign states, since ID is by definition an element of an inherent judicial personality. An external designation apparently does not satisfy that criteria. Further, norms of self-determination and or self-identification are related to the inherent right of states to determine their own national and legal state identity, particularly relevant to the principles of sovereign equality of states and the inviolability of their judicial personality. And that set of rights includes the legal status, especially representation of the member states. The so-called reference, in quotes, the former Yugoslav Republic of Macedonia, or abbreviated as FYROM, for the UN purposes only, represent an imposed and illegal denomination, not a part of the set of inherent judicial capacities or personality, is therefore an invalid ID for any proper legal representation, not only for those persons outside the UN system, but in the UN itself. Until the Prespa Agreement 2018 and interim accord with Greece 1995, Macedonia has never concluded any bilateral treaty bypassing its constitutional name, Republic of Macedonia. According to Macedonian constitutional law, only a treaty as a legal act with proper constitutional name as ID can be ratified by the parliament. Any proposed international treaty for ratification in the parliament, like elsewhere, must contain a valid ID for contracting purposes. In basically all countries in the world, its constitutional name, that is the state name provided by the Constitutional Act. And yet, it was not the case with the Interim Accord 1995 and the Prespa Agreement 2018. For that purpose, or for those reasons, many scholars, including myself, consider these treaties invalid under deficiency of crucial contracting element and ID of a state. According to the Constitution of the Republic of Macedonia, all concluded treaties by Macedonia need to be in accordance with the Constitution. And as we noticed, the PA, that is the Prespa Agreement 2018, aiming at the fundamental constitutional changes, apparently does not satisfy the criteria. Similar cases with the Interim Accord with Greece from 1995, using unofficial name in disrespect of the Macedonian constitution that provides implicit requirement that each treaty must be signed and ratified only with the constitutional name as an official name for legal contracting and international representation. By imposing the external conditions on Macedonia regarding its name, the Security Council and the General Assembly have essentially denied the right of Macedonia to choose its own name. By doing so, they practically denied even fundamental natural right of person to have a name and therefore to exist as a subject. The inherent right of a state to have a name can be derived from the necessity that a judicial personality must have a legal name or a legal identity, and that the ID defines judicial personality, providing its capacity to interact with other international subjects. This legal state's identity, by definition, is subject to constitutional law, in practice usually contained in the name of the constitution of the country. In the absence of such an identity, the judicial person, such as a state, could completely lose its capacity to interact with other such judicial persons, represent itself, conclude agreements, and so on, and enter into external and international public relations. Without a name or ID judicial person, that judicial person does not exist at all. Therefore, by essence or ID of the state is inherently crucial constituent feature of the statehood and international law prior to enter of the state into international relations. Without the capacity to enter into international relation, an entity with sovereignty, territory, and population still couldn't qualify as a state. For an entity trying to qualify as a state, a necessary feature is the ability to communicate with other public persons, and thus possession of an identity as an institution is a needed prerequisite for establishing any relations of public international nature. Statehood is incomplete without capacity to enter international relation, as indicated in the Montevideo Convention on the Rights and Duties of States, 1933, Article 1. And states are judicially equal, enjoy the same rights, and have equal capacity in their exercise, Article 4. These statements are only codification of general peremptory principles rooted in customary law and doctrine, says Professor Dr. Igor Janev, whose latest research paper published in 2023, last year, is titled The Prespa Agreement as Cultural Genocide of the Macedonian National Identity towards the termination of an illegal treaty. The Macedonian constitution, like in most countries in the world, provides that international treaties must be in accordance with the constitutional requirements, not vice versa, as in the case of the Prespa agreement. Provisional designation, as in quotation, the former Yugoslav Republic of Macedonia, could, end of quote, could not serve as the legal ID. It could not serve as the legal ID, but rather as a denial of constitutional name of a state on international and domestic level, an illegal replacement of candidate's name with illegal institution. For reasons explained above, says Professor Igor Janev, Macedonia was admitted in the UN as a nameless state, contrary to the basic norms of international public law. The constitutional state's ID name of a state is by definition an essential element of its judicial sovereign personality and consequently of its statehood, since ID is essential for capacity of any entity to communicate. Judicial personality as a set of norms and rights that comes with the emergence of a state. Before any international action, presume that a subject that needs to communicate must have a name. Must have a name. I, Silvana Pavlovska, with the name Silvana Pavlovska and communicating with you. I have a name. Macedonia has a name. That name is a legal category, an institution subject to independent will or right of the sovereign to designate territory of its sovereignty. A definition of modern statehood must contain a judicial personality, ability to enter into relations, an ID defined as constitutional name of the state that is an essential part of it. Only the constitutional name can serve as the state's official name and a valid ID for international contracting and official representation. The principles of sovereign equality of states and the inviolability of their judicial personality lead to the conclusion that the choice of a name is a basic inherent right of the state as a subject of duties, rights, and any external interference here is apparently impermissible. Impermissible, not permissible. Furthermore, the choice of the name is a basic right of any nation as collective or community with certain group collective human rights, even before creation or genesis of nation as a prerequisite, so that social community obtains or build up the statehood features and sovereignty. This basic right related to nation states ID is not alienable, divisible, or transferable, and it is a part of the right to self-determination, determination of one's legal identity. That is, it belongs to the domain of Jus cogens norms. External interference with this basic right is apparently inadmissible, since self-identification and self-accomplishment by essence needs absolute independence. If this were not true, that is, if an external factor is allowed to take part in the determination of the name of a state under the assumption that the subject state has at least a non-vanishing influence on this determination, it can easily be imagined that the process of determination of the name of that state, for example, via negotiations, may never end. The state may never acquire its name, which would create an extraordinary political and legal absurd on the international arena. It also goes without saying that if such external interference with the choice of a name of a state would generally be allowed, even though a negotiation process, it might easily become a legally endorsed mechanism for blatant interference in the internal and external affairs of the state. That is, a mechanism for degradation and destruction of its political independence. You're listening to In Focus with Silvana Pavlovska YouTube channel. Such effects of an external interference with the right of a state to choose its own name are very far from the accepted legal standards of international law. For instance, if UN decided in 1993 that all Macedonian neighbors, not just one, all of them, should be involved in naming a new state, process eventually wouldn't end ever. Never, ever would it end. The extreme form of the external interference with the choice of name of a state would be the straight imposition of the name by an external, i.e. international authority, which would simply mean a straight denial of the right of states to choose their own names and national IDs. It is easy to see that this would lead to either drastic changes of the fundamentals of presently practiced international law, or more likely to a legal chaos. From these reasons, the choice by a state of its own name must be considered as an inherent right of the state are jus cogens, which belongs stricto sensu in its domestic jurisdiction and therefore subject to complete independence and non-interference. In exercising this right, the states have, therefore, a complete legal freedom. It should be clear without saying that state's name is also in present international relations, and law a synonym for a national name, since modern international community is based on nation-state subject defined by its sovereignty and judicial personality. When the United Nations decided to deprive Macedonia from its constitutional official identity and admitted it as nameless in the organization, ultra vires act was committed by the UN organs, violating basic rights of Macedonia in the organization and damaging its reputation, rights, and dignity, even out of the scope of the United Nations system in broader international arena. The denial by the UN political organs of the inherent right of Macedonia to choose its name, implied by the additional conditions imposed for its admission to the UN membership, is therefore in violation of Article 2, paragraphs 1 and 7 of the Charter and the rules of non-discrimination. Negotiations with Greece after 3 decades led to the constitutional name change and hence flagrant and blatant interference into domestic jurisdiction of the state by other states that have adversary attitude toward national identity of Macedonian state. Furthermore, that denial on the right of choice of the national identity and even statehood apparently involves more fundamental denial of the collective human right for the nation and nationhood as a national group for self-determination, jus cogens norm, enshrined in Article 1 of the UN Charter. The respect of the principles embedded in Article 1 and especially in Article 2 are equally applicable to the organization as is to its member states. That is, Article 2, paragraph 7 explicitly forbids the organization to intervene in matters which are essentially within the domestic jurisdiction of the states. And their violation by the organization directly involves legal responsibility of the United Nations as an international person. The violation of Article 2, paragraph 1 of the Charter and of the principle of inviolability of the legal personality of states in the process of admission of Macedonia to UN membership has immediate consequences on its legal status within the United Nations as a member. With respect to other UN member states, Macedonia is obliged to bear within the UN system an imposed provisional denomination, that is the reference, and to continue to negotiate with Greece over its name, presumably on erga omnes basis, since ID of the national legal person is generally used from the state both for its international and domestic legal affairs, representation, and contracting. These additional obligations that arise from illegal conditioning of Macedonia as a UN member distinguish its position from that of the other UN members and define an unequal discriminatory status. Membership as a legal status contains a standard set of rights, and duties which are equal for all members of the organization. Sovereign equality of the members, Article 2, paragraph 1, and derogation or reduction of these membership rights and duties for particular states is inadmissible, particularly in areas which are related to or involve the legal personality of member states. It follows that the additional obligations imposed on Macedonia as a UN member are again in violation of Article 2, paragraph 1 of the Charter and obligations of the UN organization, which contributed in public delegitimization and embarrassment of Macedonia as a country that does not deserve its name to be mentioned, and embarrassment of Macedonia as a country that does not deserve its name to be mentioned, says Professor Dr. Igor Janev, an expert on international law and the author of this research paper published in 2023 called The Prespa Agreement as Cultural Genocide of the Macedonian National Identity Towards the Termination of an Illegal Treaty. We are reading chapter 2 for your benefit. As it has been written. Okay. The discriminatory legal status of Macedonia as a UN member manifests itself in a particularly clear manner in the area of representation, in all acts of representation within the UN system and in the field of UN relations with other international subjects. The provisional and not the constitutional name of Macedonia is to be used. This is in violation with the right of states to non-discrimination in their representation in the organizations of universal character. That is the UN family of organizations, expressed in an unambiguous way in Article 83 of the Vienna Convention on Representation of States. That article of the convention provides that in the application of the provisions of the present convention, no discrimination shall be made as between states. The right to equal representation of states in their relations with the organizations of universal character is only a derivative of the principles of sovereign equality of the states within the organization and inviolability of their judicial personality vis-a-vis organization as another legal person. Public deprivation from the national name and imposition of unwanted and from Macedonia despised designation was a clear example of discrimination within the membership. The representation on a non-discriminatory basis, however, has a particular significance in the exercise of the legal personality of states in their relations with other states or organizations, since it involves in a most direct and explicit way the legal entity of the states as the most important element of judicial personality. By imposition of unwanted, provisional, and humiliating ID, we may only derive conclusion that UN organization openly contributed in the process of bullying Macedonian state by another country, blackmailing it on an arbitrary basis. There is another viewpoint from which the legal status of Macedonia in the United Nations could be looked at. It can be questioned whether a state admitted to UN membership under conditions or obligations which extend in time with no specified limit and which fundamentally degrade its legal personality can be considered as a full member of the organization in the sense of the principle of sovereign equality of the members, despite the fact that the state possesses all the rights and duties provided by the membership status. Or can such a state be considered rather as de facto conditionally admitted to the UN membership? Suppose that the negotiating process may extend indefinitely. What would be the legal status of such a member carrying out a permanent obligation? Apparently, fulfillment of that obligation or condition was dependent on other state in negotiation and its recognition as it pleases. Should the FIREM be expelled from the organization's membership for not complying in an efficient way with the obligation or for its obstruction, should the other negotiating party also be expelled from the organization for the same reason, assuming that in the negotiations, the parties have equal negotiating status? But expelling the state from UN membership for failing to fulfill the obligation imposed by the act of its admission would only prove that the state had been conditionally admitted to UN membership and that it had a legal status of a conditional member of the United Nations, a status which is not provided by the UN Charter. It's not provided by the UN Charter. If expulsion from membership is not affected, to avoid the conclusion that the membership status of the state was of a conditional nature, then the organization accepts to tolerate a permanent factual non-compliance of one of its members with an obligation. It may also be possible that the obstruction of the settlement of the dispute by negotiations is caused not by the party carrying the admission obligations, but by the other negotiating party. That is, by insisting to enter into matters from the domestic jurisdiction of the first party or from other, for instance, political reasons or completely arbitrary motivations. The fulfillment of the imposed obligation could thus depend not solely on the goodwill of the party carrying the obligation, but also on the other party, that is, on a factor which is outside of its control. This introduces another component in the legal status of Macedonia in the UN membership, which is related to its independence in carrying out its membership obligations. It goes much further, says Professor Dr. Igor Janev, as the Prespa agreement later demonstrated. Treaty resulted from compromise based on the Security Council Resolution 817 and the Security Council Resolution 845 required that unnamed second party modify its national constitution with fundamental changes, not only related to the state's name, but also to the wide range of constitutional national pillars covering all national identity provisions. The Prespa agreement was erga omnes, deletion of national identity. Until that moment, Macedonian one, affecting even all no nameless minorities in Greece and worldwide, with regulation on speech, thought, and scientific and cultural deeds, and contribution in the firearm in present and even past tense. By denial of the right of the state to free choice of its national name, and by imposing to it a provisional name denomination for use only within the UN system as an attribute to its membership, the UN organization has essentially suspended the legal identity of one of its members. That is, constitutional ID at the moment and by the act of its admission to membership. The suspension of the legal constitutional identity of a member state by the act of admission defies an incomplete legal status for that nameless state within the UN, characterized by a derogated legal personality and reduced contractual capacity for conducting its international relations both within and outside the UN system. This specific status of Macedonia as a UN member is clearly different from that of all other member states and is in violation of Article 2, Paragraph 1 of the Charter, that is basic norm of sovereignty, that is of jus cogens character as judicial equality or sovereign equality. That status blatantly affects its dignity as an international subject and pose legal liability for flagrant violations of basic rights of a state. In conclusion, all the above contradictions and inconsistencies in legal status of Macedonia in the UN membership have their origin in the violation of Article 4, Paragraph 1 and Article 2, Paragraph 7 of the Charter by the resolutions of the Security Council and the General Assembly related to, respectively, the recommendation for and effecting of the admission of Macedonia to UN membership. Furthermore, these violations of the admission of placed Macedonia in dependent political, not independent, but independent political situation, contrary to the principle of independence provided in Article 2, Paragraph 4 of the Charter, as demonstrated when Macedonia was at the end of the negotiating process, basically blackmailed to change its constitution and national identity. Unbelievable, isn't it? Truly unbelievable. Let's recapitulate basic source of these UN violations and disgraceful position of Macedonia as a country which ID name should not be even mentioned. As indicated earlier, the imposition of additional conditions in the UN Security Council Resolution 817 recommending Macedonia for admission to UN membership was based on ill-posed concerns regarding the maintenance of peaceful and good neighborly relations in the region, triggered by the groundless Greek allegation that the applicant's name implied territorial claims against Greece. The Security Council didn't realize that additional conditions to candidate state may not be placed in the process of admission in the UN membership. Greece also advanced irrational claims that the right of use of the name Macedonia belongs, for historical reasons, only and exclusively to Greece. There is, however, no legal basis for linking the conditions for admission of a state to UN membership, as specified explicitly in Article 4, Paragraph 1 of the Charter, with allegations based on assumptions regarding possible future political developments. The UN Security Council at that moment didn't seem to understand baseless diplomatic Greek game, motivated only to create an exclusive brand name on the term Macedonia for themselves, by excluding Republic of Macedonia to use it forever. The UN Security Council resolved this situation in most unintelligent way by admitting a nameless country, Macedonia, nameless country, as a full member state in the UN, systematically avoiding usage of its legal name. Systematically avoiding usage of its name. Indeed, based on the principle of separability of domestic and international jurisdiction, the name of the state, which is a subject of domestic jurisdiction, does not create international legal rights for the state that adopts the name, nor does it impose legal obligations on other states, which would be a negation of the basic idea and purposes of international law, says Professor Dr. Igor Janev. Once again, we need to reiterate a conclusion that the state's name does not have an impact on the territorial rights of states, nor any interpretation of political history of any member. Furthermore, from the inherent right of a state to determine its legal identity, and from the principle that all states are judicially equal, it follows that all states have an equal legal freedom in the choice of their names. For this reason, the Greek claims that Greece has an exclusive right to the use of the name Macedonia have no basis in the international law and practice. No basis in the international law and practice. The Greek opposition to the admission of Macedonia to UN membership under its constitutional name is not only without legal basis, but it is also in violation with the international law when interfering in matters which are essentially within domestic jurisdiction of Macedonia and in international affairs as well. Thus, by ignoring the principles of separability of domestic and international jurisdictions in the case of the Macedonian admission to UN membership, the Security Council has opened the door for blatant violation of several articles of the UN Charter and for creation of an unusual and illegal membership status for one of the UN members, not instituted by the UN Charter. By doing so, the Greek idea of erasing the national identity of Macedonian state and Macedonians in Greece and worldwide, including Australia, became quite a real one. And by using erga omnes principles with respect to ID, brought in fact rising instability in Macedonia and the Macedonian region, or the Balkan region as it is referred to nowadays, rather than stabilizing regional relations as expected. From the fact that Greeks only recently in the 80s started a campaign to change the names of its provinces in into Macedonian names, we may conclude that all action regarding denial of the rights of a state's identity in the UN and the UN was motivated primarily with commercial goals. The Greek government, with the Prespa agreement, succeeded in effect of artificial creation of a brand name excluding and banning ethnic Macedonians from the Republic of Macedonia, that required naive monopolization of ancient history of the Macedonian kingdom and Alexander the Great as a Hellenic hero, not connected to present inhabitants of North Macedonia, but only to the Greeks. (2.4) Legal responsibility of the UN organization and the modes for redress, particularly in cases such as Macedonian admission and its discrimination. In the preceding sections of this study, we have provided a number of arguments which show in a clear way that the inclusion of additional conditions in the Security Council Resolution 817 of 1993 confirmed the Security Council Resolution 845/1993 and the General Assembly Resolution 47/225 of 1993 related to the admission of Macedonia to the United Nations membership violates the provisions of Article 4, Paragraph 1, Article 2, Paragraph 1, and Article of the Charter, and constitute an ultra vires acts of these organs. Ultra vires acts of these organs. We also indicated that provisional reference replacing the legal name as a consequence of conditionality represent an invalid institution and therefore an invalid ID of the state, out of scope of the set of legal capacities related to the state's judicial personality. By definition given in the UN resolutions, it is not a name, but rather a designation for an internal use in the UN. Therefore, it's not even replacement for the name, since the idea was the name the name should be negotiated with the other state in the process. For that reason, we concluded that state that is Macedonia, was admitted with no name on a basis that it needed to be designated in the interaction with two countries. Since the admission to membership, affected by a decision of the General Assembly, expresses the legal capacity of the UN organization to admit a state to membership, and since a state also has a legal capacity to become a member of the organization, it follows that the act of admission engages the legal personalities of both the organization and the applicant state, and that the admission is a legal act of the organization. As argued in this chapter, the responsibility of the organization related to the unlawful admission of Macedonia as a nameless subject or person to UN membership derives from the right of the applicant to admission when it fulfills the prescribed criteria laid down in Article 4, Paragraph 1 of the Charter, and the duty of the organization to admit such applicant to membership on non-discriminatory basis, following from the openness of the organization and its mission of universality, and a norm of legal equality that was affected by illegality of provisional name. In this context, as mentioned above, the provisions contained in Article 4, Paragraph 1 must be interpreted as a legal norm of an international treaty which governs the admission to UN membership. From the character of the Charter as a treaty bounding states and organization, it was blatantly clear that artificial denomination that violated judicial personality of the Macedonian state by this organization or the UN as accomplice and creator of violation unlawfully degraded and mutilated the personality of the candidate for membership and later a member state. In addition, by admitting the nameless state, the UN organs violated internal legal order of the organization itself, the order that was supposed to be protected by those UN organs and member states of the organization. Observance of legal norms related to admission, suspension, and expulsion from the UN is compulsory for the organization as it is for the applicant state and member states. The violation of Article 4, Paragraph 1, in the process of admission of Macedonia to UN membership constitutes, therefore, a breach of the Charter and the constitutionally guaranteed right of the applicant by the organization. The specific content of the violation of Article 4, Paragraph 1 is the extension of the admission criteria by the UN political organs beyond those enumerated exhaustively in that article and other norms of the UN Charter, that is, an inappropriate and politically motivated interpretation of Article 4, Paragraph 1, contradicting the interpretation of that article given by the International Court of Justice in the admission case and accepted in 1948 by the General Assembly. By imposition of a nickname replacement for a name with the view that present candidate did not have a recognized legal ID and that needed to obtain it during the membership, the UN organs in fact advocated irrational view that candidate for membership falsely represented itself in the moment of application for membership. If that would be the case, hypothetically speaking, then such imposter state shouldn't be admitted to the UN at all. It appears that members of the UN Security Council didn't grasp a single legal principle that disputes over states' name among the international public persons could not exist at all. In order to reconcile Greek interests, claims that Macedonia was an imposter, and its legal procedures, UN Security Council committed an extremely unlawful act, in brackets, apparent mistake, by replacing legal ID of the applicant with an illegal nickname, violating not only the legal order of the organization, but the basic rules of the general international public law applicable out of the scope of the UN organization. Namely, the organization admitted Macedonia in an undignified manner as sort of a nameless imposter or intruder with an irrational obligation to define its proper universal name by nature erga omnes during the period of its membership associated with mandatory cooperation, negotiation, and final consent given by the Greek government on naming a state by plaintiff that actually accused the candidate for UN membership of being an imposter. From the legal point of view, the breach of Article 4, Paragraph 1 of the Charter by the organization in the case of the Macedonian admission to the UN membership is legally similar to the IMCO case discussed in the section previously, in which the breach of Article 28 of the IMCO Convention by the Assembly of IMCO was committed similarly because of an inappropriate interpretation of the provisions of that article, resulting in additional criteria for election in the IMCO Maritime Safety Committee membership. As argued in Section 3 in this chapter, the determination of the legal identity of a state is an inherent right of that sovereign nation state, falling strictly within its sovereign domestic jurisdiction that is inviolable and not subject of negotiation or approval by other state or organization. This comes from the international custom as derived from the general practice of states and the general legal principles recognized by civilized nations. This inherent right for an independent determination of the legal identity of a state being strongly linked with the national collective right to self-determination belongs to the domain of jus cogens. Therefore, in international law emerged a jus cogens principle that disputes or differences over states' name among states could not exist, as this matter is within its sovereign domestic jurisdiction that is inviolable, and thus sovereign identity is not negotiable. It's inviolable. Furthermore, the legal identity as a constitutional name of the state is an essential legal element of the indivisible legal personality of a state existing prior to its entrance into international relations, the inviolability of which has again character of a jus cogens form. or norm. The denial of the right of a state to determine its own name as legal capacity is, therefore, in violation with the norms of jus cogens, reflected in the provisions of Article 1, Paragraph 2, Article 2, Paragraph 1, and Article 2, Paragraph 7 of the Charter, and in the Declaration on Principles of International Law. The organization, as an other subject of international law, as any other subject of international law, has a duty to respect these, what they call peremptory norms. Articles 2, Paragraph 7, specifically and expressly limits the powers of the organization over matters from the strict internal jurisdiction of the states, and that can prevent the state to conduct its international relations. The breach of this article in the case of the Macedonian admission to UN membership by interfering in the inherent right of this state to choose its own name and, in fact, to have one is certainly an ultra vires act of the organization, particularly after introduction of humiliating name, the replacement, the FIREM, as a membership degradation. The organization bears a legal responsibility for this unlawful act or similar acts against international person and basic capacities existing prior to the entrance in international organization. Since the basic principles embodied in the Charter are mutually interrelated and consistent with each other, breach of one of the principles or legal norm leads usually to violation of other principles or norms. Thus, the violation of Article 2, Paragraph 7 leads also to violation of the principles enshrined in Article 2, Paragraph 1, as generalized by the Declaration on Principles of International Law, sovereign equality of states, and vice versa. Furthermore, the violation of Articles 4, Paragraph 1 and Article 2, Paragraph 7 during the process of admission leads to a discriminatory legal status of Macedonia as a UN member, i.e., to violation of Article 2, Paragraph 1 of the Charter. Indeed, ex injuria jus non oritur, as we have argued in the preceding section, the breach of this article results effectively in suspension of the legal identity of the member state, inflicting thus a grave damage on its legal personality, that is, by reducing its contractual capacity, its basic capacities in the domains of legation and representation, and affecting its external political and economic relations, particularly placing Macedonia in a dependent position on other state member of the UN. We're talking about Greece placing Macedonia in a dependent position. As mentioned above, Macedonian constitution de facto became dependent on the Prespa agreement as external treaty, regulating pillars of national constitution. The responsibility of the organization for violating Article 2, Paragraph 1 derives from its duty to strictly observe UN Charter as a treaty and its provision, principle of the organization, and especially from its mission in promoting the legal justice and the rule of international law embedded in the UN Charter. That includes the fact that the organization is a legal person, vis-a-vis a state member, as another independent legal person in contractual relations with the UN organization, and that contract charter must be governed by bona fide and with mutual respect, not humiliation by renaming or nicknaming imposition or under potential a prior presumption that a state is or was an imposter. By imposing of an illegal name, replacing constitutional official name, UN in fact made Macedonia falsely representing by the provisional UN reference instead of its legal official name. Therefore, UN was an initiator and an accomplice in the process of fake representation using a denomination FIREM as illegal institution resulting from illegal additional conditions instead of a legal name of the country, which is Republic of Macedonia. The case of the UN Security Council Resolution 845 clearly demonstrated involvement of the UN in actual forcing of a member state for illegal representation of itself in the UN organization as the firearm, and thus self-humiliating. Let's analyze a situation before the conclusion of the Prespa Agreement 2018 and possible modes of action by member states after the Prespa Agreement. The violations of the UN Charter provisions contained in Articles 4, Paragraph 1, Article 2, Paragraph 1, and Article 2, Paragraph 7 may each serve as a sufficient legal basis, ultra vires acts, for requesting a judicial redress, i.e. for removal of the conditions imposed on Macedonia during its admission to UN membership and the resulting discriminatory legal status as a UN member with replaced identity. On the substantive level, the mentioned violations are all closely interrelated, as we've argued, since the violation of Articles 2, Paragraph 1 and Article 2, Paragraph 7 underlines the violation of Article 4, Paragraph 1. On the other hand, the breach of Article 4, Paragraph 1, which implies the violations of Articles 2, Paragraph 1 and Articles 2, Paragraph 7, appears to be the source generating the problems related to the specific legal status of Macedonia in the United Nations membership and loss of its political independence vis-a-vis Greece in violation of the norm embedded in Article 2, Paragraph 4. Further, the breach of Article 4, Paragraph 1 appears to be most obvious since the admission of Macedonia to UN membership has not followed in its substantive part the standard admission procedure. Moreover, and most importantly, this breach is in direct discord with the General Assembly Resolution 197, Paragraph 3A, regarding the interpretation of Article 4, Paragraph 1, given by the International Court of Justice in the admission case. As a mechanism for judicial redress of legal consequences generated by the violation of Article 4, Paragraph 1 in the General Assembly Resolution 47/225 from 1993 and the Security Council Resolution 817 from 1993, the advisory jurisdiction of the International Court of Justice appears to be the most appropriate in this case. The question of legality of these resolutions in their parts related to the imposition of additional conditions of Macedonia regarding its name for its admission in the UN membership, that is, their compatibility with the provisions of Article 4, Paragraph 1 of the Charter, could, in described circumstances, be put before the court by the General Assembly on request by Macedonia, possibly jointly with a group of member states that have already recognized Macedonia under its constitutional name, which is Republic of Macedonia. Since this question is of purely legal nature, the General Assembly may request for it an advisory opinion from the court, Article 96, Paragraph 1 of the Charter. The General Assembly cannot obstruct such a request for an advisory opinion hereafter AO of being put before the court because the requested opinion is related to the legality of its own act. Such an obstruction, based on whatever reasons, would essentially mean that the General Assembly, as a political organ, is imposing its own response to the question regarding the legality of its own act, or imposing its own judgment in a case in which it is itself a party representing the organization obliged by the Charter. This would be incompatible with the basic legal principles of judicial equality and bona fide, and with the mission and the duty of the UN organization regarding the respect of international law. Moreover, the earlier discussed IMCO case provides an example in which the organization has not obstructed the request for a court's advisory opinion regarding the compatibility of a decision of IMCO plenary organ with the provisions of its constitutional document. On the other hand, since the question regarding the legality of imposing additional conditions on Macedonia for its admission to UN membership is essentially a special case of the more general question of the same character already considered by the court in the admission case, there cannot be any uncertainty about the court's competence for its consideration. For the same reason, and from the obvious incompatibility of the additional conditions for Macedonian admission to UN membership, with the exhaustive character of the conditions set forth in Article 4, paragraph 1 of the Charter, the court's advisory opinion in this case cannot be different from its opinion already given in the admission case. Similarly, the position of the General Assembly with respect to the court's opinion in the Macedonian case cannot be different from its position taken with respect to the court's opinion in the admission case. In fact, the Macedonian case is only a specific example of the general issue considered by the court in the admission case, created by the non-observance or neglect of already adopted court's interpretation of Article 4, paragraph 1 of the Charter. The mode of redress via the advisory jurisdiction of the court includes also the more subtle problem of the legal consequences of legal defective General Assembly Resolution 47/225 of 1993. Apart from its preamble, referring to the recommendation of the Security Council for admitting the applicant to UN membership with additional conditions and to the application of the candidate, the General Assembly Resolution 47/225 of 1993 contains a decision which in fact includes two parts. A, to admit the applicant state to membership in the United Nations, and B, this state being provisionally referred to for all purposes within the United Nations as former Yugoslav Republic of Macedonia, pending settlement of the difference that has arisen over the name of the state. Part A of the General Assembly resolution reflects the assessment of security. Oops, seems to be a page missing here. So what we shall do is, oh, here we are. We found it. So, Part A of the General Assembly resolution reflects the assessment of the Security Council that the applicant fulfills the criteria for membership laid down in Article 4 of the Charter and follows the Security Council recommendation for admission of the applicant state to UN membership. Part B of the GA resolution contains the imposed and therefore illegal additional conditions related to the name of the applicant and ID of the future UN member, without the acceptance of which Part A could not have been effected. Only Part B of the GA resolution is ultra vires, and only this part can be considered as void. From the requirement of legality, the unlawful Part B of the General Assembly resolution should be considered as void ab initio. However, practical consideration within the General Assembly after the favorable court's advisory opinion is received and presumably adopted may render the determination that Part B of the resolution is void ex nunc, E-X-N-U-N-C. In either case, according to the principle of separability, the invalidation of Part B of the resolution should not affect the validity of Part A. Obviously, the invalidation of Part A of the General Assembly Resolution 47/225/1993 can be done by a new General Assembly resolution, which would also affirm the use of constitutional name of Macedonia within the UN system. The above from or mode of redress was not known to the Macedonian government and public before I published my scholarly article in the American Journal of International Law in 1999, volume 93, number 1, says Professor Igor Janev, the author of this scholarly paper. With respect to the usage of an advisory jurisdiction of International Court of Justice, ICJ, there was also another ground or possibility for a judicial redress based on the violation of Article 2, paragraph 1 of the Charter of the General Assembly Resolution 47/225/1993, by which the legal personality of the state was severely derogated through suspension of its legal identity and imposing a discriminatory membership status. The question of derogation of legal personality of Macedonia by the GA resolution in the context of Article 2, paragraph 1, has an obvious legal character and is therefore a legitimate subject for the court's advisory jurisdiction. Since some of the basic principles of international law are involved in the subject, related, for example, to the inherent rights of states, inviolability of legal, we now come to page 66, personality, legal equality of states, and so on. The court could not formulate its opinion in a manner inconsistent with those principles, nor could the General Assembly ignore the court's opinion based on such principles. Furthermore, based on present legal analysis, we can derive more general conclusion that in every case, external denomination or reference for the state as imposed category by its essence, replacing the constitutional ID, couldn't be regarded as a legally valid identity of an international subject for any legal purposes whatsoever. As we will address this matter later, at this point, we should only indicate that neither provisional nor permanent externally imposed or induced denomination or designation replacing the constitutional identity, that is the constitutional name, may not be considered as part of judicial personality as inherent set of rights and capacities of the sovereign entity, such as state. Superimposed and unchangeable by external act identity that dependent on external political will or act certainly may not be covered by category of sovereign identity or identity freely chosen by the people and from the people in the process of self-determination and self-identification. If any name is externally imposed against the will of the people, as is the case in the Macedonian renaming, that name would not be received by the people as their choice and will be subject of the resistance and despise. It should be mentioned that before the renaming of state nation by Prespa agreement, the second party in that agreement was recognized under the name of Republic of Macedonia by more than 140 member states of the UN in bilateral relations, including 3 permanent members of the UN Security Council, namely the United States of America, Russia, and China. Clearly, members of the UN came to understand that the right of choice of a legal identity belonged only to a sovereign state, and thus, from initially 15 countries, number of states who recognized the Republic of Macedonia increased to more than 2/3 of all member states in the General Assembly in the United Nations. Presently, 194 members comprises the UN Assembly. If the Macedonian government only proposed resolution to the UN General Assembly to extend its membership with the applicant name, that is Republic of Macedonia, that might end all the troubles and hardship for that country, becoming today a victim of Greek caprice and essentially be coerced to conclude the humiliating agreement with that state, with imposed revisions of its national identity. Such revision of the identity of the state apparently undermines general definition of a state as an independent and sovereign entity. And thus, in such circumstances, we may argue that revised entity represent a new subject in international relation different from the previous one. That is the end of Chapter 2, contained in the Prespa Agreement as cultural genocide of the Macedonian national identity towards the termination of an illegal treaty, published in 2023 by extinguished Professor Dr. Igor Janev. You've been listening to In Focus with Silvana Pavlovska. Thank you for your attention, and I'm looking forward to seeing you for Chapter 3 of this amazing piece of work.